length behind somebody 65 miles an hour.
Okay, we are on the air. I'd like to welcome everybody to the special meeting of concerning the Issaquah Highlands Retail Site Development Permit, the Issaquah Highlands Medical Office Administrative Site Development Permit, and the Issaquah Highlands Self-Storage Administrative Site Development Permit. Remind everybody that we are being recorded, and so if everybody could speak up and make sure you lean into the microphone so we can hear well, that would be really helpful. And with that, I'll just we'll check Ms. Carre. Carre, we'll turn the time over to you.
Thank you. We'd like to recall Tia to continue her testimony. So Tia, do you acknowledge that you are still testifying under oath? You were sworn in a few nights ago.
I am.
Okay. So I'd like to pick up where we left off yesterday evening. And just to bring us back to where we were at in time, it was roughly after we'd gotten through the two applications, the medical office building, and then also the retail pre-applications that were submitted, and we kind of ended on that note.
Okay.
So I wanted to turn next, going back to your meeting minutes binder, to a meeting that happened on October 24th, 2017. Will you flip to that for me, please?
Okay.
So what was the meeting that happened on October 24th of 2017?
I believe this was the collaborative meeting for our storage application.
Okay, and if you turn to the final page of your notes there, what did Ms. Sloman have to say about the preliminary application process for SDP, ASDP applications?
Well, she maintained her position that pre-apps were required, and she referenced that they may be called something else in the development agreement.
Are you aware of anywhere else in the development agreement where pre-apps are referenced or required for SDPs or ASDPs?
No, there's no steps before the application called out in the development agreement.
What role does ARC, and I think you described it to me in the Architectural Review Committee last night, what role do they play in all of this?
So the Architectural Review Committee is a committee or commission, I don't remember which, of the Issaquah Highlands Community Association, and they conduct the architectural review of anything that gets built up there. Their role, to my knowledge, is separate from the city process, although I think that the city and IHCA have created a process where they overlap some. And I know on our applications, we were required to submit ARC approvals, which we did for all of our applications early on in the process.
All right, and I'd like to turn next to Exhibit S31. Should be in your binder here. Yep. Okay.
Okay.
Can you describe what the document is at S31, please?
This is a letter dated October 25th, 2017, and it is addressed to Mr. James Haney at Ogden Murphy Wallace, and it is from Patrick Mullaney.
And what was your understanding of the purpose of this letter?
It states that the purpose of this letter is to explain IHIF Commercial's position on both the vesting for the proposed zoning and the vesting under the Grand Ridge Development Agreement, and to solicit your input so that both parties can hopefully obtain clarity and reach timely agreement on the applicable vesting rules and process.
And then if you turn to page 4 of that letter, and I should have asked this at the outset, did you receive a copy of this letter at this time? Were you aware of the letter?
Yes, I did.
And so on page 4 there in section B, can you read that first sentence in that section?
It says IHIF Commercial also asks the city to confirm how it will address the vesting and processing of IHIF Commercial's current and pending pre-application submittals.
So did Shelter ask for an interpretation on vesting?
Yes, that's what this letter does.
Was this the only time that Shelter asked for an interpretation from the director on vesting?
No, I think we asked for it multiple times, both verbally and probably in email and in this letter as well.
Let's turn back to the meeting minutes, this time looking at the meeting that happened on October 26th, please.
Okay.
So what was the meeting that happened on October 26th of 2017?
So this was the collaborative meeting on our office, or sometimes called commercial or office fit/fitness application, which was on Block C.
So the collaborative meeting, was this the kind of the starting point for that application?
Yes.
And I'd like to introduce a new document into the record. This is going to be S57. Tia, can you please describe what the document is at S57?
This is an email chain between me and Lucy Sloman.
So if you turn back to, in the email chain to the Friday, October 27th, 2017 email, what did Ms. Sloman have to say?
Her email to me says, Tia, the city's position is that the meetings we are discussing with you are provided in the development agreement, though they have different names. They are marked optional, and that decision is at our discretion. We believe they benefit everyone in improving the conformance of the SDP submittal to the development agreement. Regards, Lucy.
So let's go up to your response, the next email in this chain. It's dated 10/30/2017. What was your response to Ms. Sloman's email?
Well, I thanked her for her response and disagreed with her interpretation that optional actually meant at her discretion. I think it's pretty clear that in a code, like is enacted by the development agreement, that if something were at the discretion of the city, it would say at the discretion of the city or required at the discretion of the city, and not optional. Also, how's the best way to describe this? The triggering event for a pre-app meeting would be filing of a preliminary land use application by the applicant. So it's something that is necessarily in the control of the applicant. So it would make no sense for optional to mean at the discretion of the city.
And does the development agreement, and specifically Appendix L, is it your understanding that Appendix L provides for any discretion in terms of whether the city can require a collaborative or pre-application meeting?
No, the development agreement is really clear that it is optional at the option of the applicant, and there's actually some additional text in Appendix L that we cited in this email back to them.
So after this point, did you still understand that the pre-application meetings and the collaborative meetings were something that was required?
I understood that per the development agreement, they were not required, but per the staff, they were being required regardless.
Let's turn now to Exhibit C6 in the record.
In the other one.
There. Tia, what's the document at C6?
This is a memo that was written by Keith Niven and Lucy Sloman and was provided to either Land and Shore or the council, I'm not sure which.
I'm going to introduce, kind of to help to clarify with that, a new exhibit which will be S58. What is the document at S58?
S58 is a memo from Lucy Sloman and Keith Niven addressed to Council Land and Shore Committee. And it references a number of attachments, one of which is called out as the vesting white paper. And I believe that the vesting white paper is actually the Exhibit C6.
Okay, so that would have been an attachment to Exhibit S58.
Yes.
So if you scroll down or flip through the pages in your case, in that document to page 7 of the document, there's a section called vesting. What did the city indicate, or I guess it was Ms. Sloman and Director Niven that were writing this memo, what did they indicate with respect to vesting at that time in this memo?
In the memo that is S58, it says vesting, provided discussion draft on the issues associated with vesting. And then discussion says see attachment 4, and recommendation says include the proposed vesting language, which has been slightly edited for clarity. And then it says see 1819B 360 for the proposed language.
So let's turn to attachment 4 that this is referencing, and that's Exhibit C6 that we had just pulled up. And I guess this was an attachment from the city. Do you know who it was from specifically, or who prepared this?
My assumption was always that Keith Niven had prepared it because he had offered at a previous meeting to write a vesting white paper for the Land and Shore Committee, and then this one came out after that. So my assumption is that Mr. Niven wrote it.
Let's turn to the second page of C6. There's a section called evaluation there. What did this white paper have to say, or what did Director Niven have to say about vesting and this West Main issue that we heard Patrick Mullaney testify about?
Well, it explains that the administration supports what's called out in the memo as alternative 2 because it's consistent with the vested rights doctrine and the West Main v. Bellevue decision. And then it goes on to state, since the administration requires a land use permit to be issued prior to the submittal of a building permit, a complete land use permit has been viewed by the administration and city attorney as part of the building permit process. So this was totally consistent with our understanding of vesting law and also with all of our previous conversations with the city and our understanding of their both previous and current practice with respect to vesting throughout the city of Issaquah.
And what practice was that it was consistent with?
Acknowledging that because the land use permit is required, and actually because the preliminary land use application is so extensive, that they had to recognize that vesting occurs at complete preliminary land use application. And that's what Keith had told us many times verbally and what our experience was in the city of Issaquah.
So in your experience, if you were to go apply for a building permit without a complete land use permit, what would happen?
I don't believe that a building permit would ever have been accepted without a land use permit. That was very clear from both conversations with staff, but also from the building permit submittal checklist itself. And it just was not an option. Plus, you have to understand, a building permit isn't something that you just do quickly. It's really expensive. So, for one building, you're talking hundreds of thousands of dollars to pull together a building permit. So, it's a significant requirement. And so, what the city was doing and explaining at this point in time made a lot of sense and makes a lot of sense.
You mentioned the checklist a minute ago. Let's turn to those checklists. One of them is in the record already as S9. And it should be in front of you in this binder.
In this one?
Yep.
Okay.
Okay, so a minute ago you mentioned the checklist. Is S9 the building permit checklist that you were referencing?
It is.
And specifically, what types of projects does this one apply to?
So this one is for commercial and multifamily building permit submittal requirements.
So is this the checklist that would apply to shelters projects?
Yes.
If you scroll down or turn to the second page, what does it say in terms of the pre-submittal requirements for a building permit?
Well, the first one is land use permit notice of decision has been issued. There's no way that you can have a notice of decision issued if you don't have the permit approved. So it makes very, very clear that that's a requirement.
And just to clarify for the record, a notice of decision, what's the difference between that and a complete application? Can you just kind of describe high level what that process is?
Yeah, a notice of decision comes out after the decision is issued, and so that's the public notice that the decision has happened.
Okay, so that's the final decision on that permit application.
Correct.
And then let's turn to a new exhibit, which will be S59. What's the document at S59?
This one is called Non-Residential and Multifamily Construction Permit Submittal Requirements.
So the title might be self-explanatory, but what types of projects would this one apply to?
I think anything that's non-residential or multifamily.
And if you turn to the second page on this one, what's required in terms of the pre-submittal requirements for a building permit for these types of projects?
It has the same notation, that a land use permit notice of decision has been issued.
If you go down to the very bottom of that page, what's the date of this form?
This one shows a date of December 16th, 2016.
And if we turn back to S9, the exhibit you were looking at before, is there a date on that checklist?
It looks like there's a really light date that says updated September 26th, 2017.
Okay, and I'm seeing that too. I'm looking specifically at page 2 of the document, might have the highest quality of the date. But
Yeah.
okay.
Oops.
And so two different dates on two different checklists. Is that consistent with your experience working in Issaquah? That this requirement of having a land use permit prior to building permit was a longstanding requirement in the city?
Yes, I mean, that's what it says in the memo that was written by staff as well. And I think there's lots of instances of the various public meetings that they spoke at leading up to the replacement regulations adoption where they acknowledged that.
Let's turn back to that memo at C6.
Yes,
Were you here for Director Niven's testimony?
I was.
Did you hear him make reference to the fact that he viewed this memo and specifically the West Main issue that's presented in it to be in error?
I did, and I thought that was a bit disingenuous, given that this has been a topic of discussion that has been brought up over and over and over again since the time this memo was written. Throughout the process of the replacement regulations, we made many comments, both written and verbal, at the hearings and meetings about this issue, and citing back to this statement in particular. And there were many opportunities to correct it if it were in fact in error. Both by Mr. Niven had the opportunity to correct it, Ms. Sloman had the opportunity to correct it, and City Attorney Jim Haney would have had the opportunity to correct it, since it references specifically that it's both the position of the administration and the city attorney. And no one ever made that correction. No one ever made that assertion that this was wrong until this hearing.
Let's turn back to your meeting minutes now for a moment, please. I want to take a look at a meeting that happened on November 6th of 2017. So can you describe, well, first of all, your recollection of who was present at that meeting on November 6th, 2017?
I believe that meeting would have been Keith Niven, Gary Young, and myself.
And what was the purpose of that meeting?
I believe the purpose was to talk about where they were with the replacement regulations and that process. Also talk about what the potential path forward for development of our property might be, besides the applications that we had pending at that point. It was sort of a meeting on all the various topics that were in play at that point in time.
If you look down in your notes there to the 5th bullet point down, what did Director Niven have to say with respect to Shelter's involvement in the replacement regulation process?
So what my notes say are, he asked that we, quote, stop poking at us, end quote, and, quote, stop asking people to come speak, end quote. He said that neither staff nor council are stupid, and they know that people showing up are only showing up because we ask them.
Is that true, that people were only showing up because you were asking them to show up?
No.
And then if you move further down the page, this is towards the end of the page, there's some of your notes are discussing the vesting process. What did Director Niven have to say with respect to vesting in this meeting?
Again, I'll just read from my notes. It says, on vesting and process, he explained pre-app is optional, but if you elect to skip it, there's no way staff would be able to understand your application. It would be like a foreign language, and they could therefore not determine if it was complete.
What did he say about the timing of when SDP applications would vest?
He said that SDP applications vest and that happens at the preliminary land use application.
Had staff given any advice to council at that time in terms of what they might be able to do with the replacement regulations and how that would affect vesting?
Yes, at that meeting, he told us that staff had advised council that they could make a, quote, policy decision to retroactively remove the vested status from applications that were submitted under the development agreement. We obviously objected to that and told him that that was not something that council could legally do.
And from your comment, it sounds like maybe I understand the answer, but to be clear, is it your understanding that legislation, based on your experience, that legislation can retroactively strip vested rights?
No, it absolutely can't. The law is very clear on that.
All right, the next exhibit will be S60. Tia, will you please describe the document at S60?
This is an email from Tom Goltz to me and to Patrick Mullaney. Tom is or was the attorney for Port Blakely, the master developer under the Issaquah Highlands Development Agreement.
And what was the purpose of Tom Goltz's email? Why did you reach out to him? Why did he respond?
We had reached out to him because we were struggling with some of the positions that the city was taking on various issues. To sort of run through them briefly, one was Appendix L. The city had at various points given various different explanations as to what the status of Appendix L to the development agreement was. And just to refresh your memory, that's the one that deals with permit processing and timelines. So at one point, Mr. Niven explained to us that, well, Port Blakely used to fund the MDRT, which was the permit review agency on behalf of the city that reviewed things in Issaquah Highlands. And since Port Blakely doesn't fund that anymore, we've decided that Appendix L no longer applies, and we're just going to apply the Issaquah Municipal Code. And so that was one of the questions we asked Tom about, and his response was clear that no, to his knowledge, Appendix L is still in effect, and there was never anything that amended it. There was a study that had been done at some point by an outside consultant, and a different funding arrangement had been tried out, but it was temporary in nature, and when it went away, the default was back to Appendix L. So that was one of the issues that he commented on. He also responded to our question about the optional pre-application conference, and he stated, to me, Appendix L clearly makes it the applicant's option and not the city for convening a pre-application conference. So his position was the same as our interpretation, and this is coming from the guy who had been involved from the very beginning in the drafting and everything else. On behalf of the master developer. There had also been issue raised by the city about whether we had rights under the development agreement or just obligations. Again, Director Niven took the position that we had no rights to enforce the development agreement against the city, that we only had obligations to follow it, and along those same lines that we didn't have rights to ask for an extension with respect to our property. So again, he addresses those issues and explains to the city that in fact, as a property owner, we have rights, and also beyond that, as a designated successor, which was a specific status under the development agreement that we had been assigned by Microsoft, who had gotten it from Port Blakely, the master developer, that we had rights there as well.
And that, this email was between you and Tom Goltz at Shelter, but that position that he provided to you, was that also provided to the city?
Yes, and I believe he wrote directly to the city as well.
Let's turn now to Exhibit S33. It's already in the record. So this was a document that Patrick Mullaney had testified about, but can you remind us and just describe to us what this document is?
Yes, this is a November 9th, 2017 letter to Keith Niven from Patrick Mullaney regarding the Grand Ridge Development Agreement mitigation.
So with respect to mitigation, why was this letter provided by Mr. Mullaney?
I believe he had earlier provided another letter on mitigation, but again, at various times, Mr. Niven asked for more from us and our attorney on the mitigation. He always would say that he was forwarding it on to the city attorney for comment and response.
Do you recall if you received comment and response?
I don't believe we ever did.
So this letter was dated November 9th. Also around, I'll just represent also around that time on November 9th was when the office SDP application was being prepared. Does that sound consistent with your memory as well?
Yes.
So again, we have a series of exhibits similar to last night. We'll introduce them as one exhibit number, but have separate parts A, B, C, D, et cetera. So we're going to move through that for a minute here. All right, so these are going to be Exhibit S61. And starting with S61A. Tia, what's the document at S61A?
This is a graphic related to our commercial office site plan for Block C.
And S61B.
And this is another graphic related to the same SDP. The S61A is the first floor, which shows the health club and retail, and S61B shows that there's office above, and also shows parking layout and the interaction with the adjacent retail.
Okay. And then S61C.
And S61C is a title commitment or a subdivision guarantee from First American, again, just showing ownership and exceptions or things that are recorded against title.
And then S61D.
S61D is a pre-application meeting submittal requirements checklist.
And is this related to the office as well, specifically?
Yes, I would assume so.
So then we have S61E. Can you describe what that document is?
This looks like it is a memo that has some of the facts related to the proposal for the office on Block C.
Okay.
And it's specifically regarding solid waste service.
And then S61F.
S61F is the brief project description.
And S61G.
S61G is a land use permit application for the preliminary land use application for the office building on Block C, Lot 6.
And S61H.
So S61H is the main packet of the submittal of the preliminary application for Block C. So again, this one has a lot of components to it. It has analysis of site views and photo views from various points, both on and off the site and along the frontage. It has mapped out the natural and man-made features of significance that are around the site. It deals with site access, opportunities and constraints. It deals with, there's a plan that deals with bike and pedestrian circulation. There is a plan for vehicular circulation. There's a plan for parking. There's a plan that shows community context. In looking at the neighboring context, there's massing drawings that show the scale as compared to other things both proposed and built around it. There's several pages of images of that. There are building inspiration photos. There are several pages of engineering work. There's a preliminary landscape diagram and landscape character images and amenities. So it's a pretty significant packet.
Okay, and then the next one is S61I. Will you describe what that is and how it ties into what you were just looking at S61H?
S61I is the more complete project narrative, which has the shorter description of the property, but it also, and the project, but it also includes how the project conforms to the traditional townscape neighborhood guidelines. And it has a section that discusses ownership and maintenance responsibilities of the improvements as well.
And then S61J.
S61J is a transmittal sheet from Collins Warman, who was our consultant on this, that was the cover sheet for all of the things that were submitted.
All right, and then this last one in this packet would be S61K.
So S61K is an email from Jean Lynn, our planner at the city, to David Holmes, our consultant contact on this project. And the email says, attached, please find our pre-application comments for the proposed office building. And this email is dated January 16th, 2018, and our pre-app submittal transmittal sheet is dated November 8th, 2017.
So a couple of months in between.
Yes.
Okay. Let's turn now to exhibits S34 and S35.
Okay.
So we heard Mr. Mullaney testify about each of these, but can you remind us what the exhibit at S34 is?
So S34 is an email to Keith Niven from Patrick Mullaney that references an attached copy, electronic copy of a letter that was being mailed on behalf of IHIF Commercial, requesting a meeting per the Grand Ridge Development Agreement dispute resolution paragraph.
And what were some of the main issues that you were concerned about resolving through a dispute resolution process?
The issues called out in that email are the vesting for IHIFC's plat and site development permit preliminary applications, applicable mitigation, and the proposed FAR and structured parking requirements.
So then at Exhibit S35, is this the letter that was attached to that email?
It is.
And so what does the letter do? What's the purpose of that compared to the email?
The letter was to formally invoke the dispute resolution provision of the development agreement, which then required a dispute resolution meeting within the 7 days following that notice.
So if you go down to the third paragraph there, and I'm looking at, on the first page, and I'm looking specifically at the second sentence that starts with despite repeated requests. Can you read that sentence, please?
Yes, it says, despite repeated requests, the city has not acknowledged whether it considers IHIFC's site development permit preliminary applications vested to the development agreement's development standards.
And can you continue reading there as well?
The city has also refused to follow the city review procedures and standards established by Section 3.22.1 and Appendix L for the timely processing and complete application decisions on IHIFC's site development permit preliminary applications.
So the first sentence that you read, despite repeated requests, does that go back to what you mentioned to me earlier in terms of asking for interpretations on vesting? Is that the same thing that it's referencing, or is it something different?
Yes, it's generally the same thing.
And so this was dated November 15, 2017. Was there a follow-up to this letter?
There would have been a meeting that happened after this, and in response to this, there was also email communication between Mr. Niven and myself where he acknowledged that our preliminary land use applications were vested to the development standards under the development agreement.
Let's turn to your meeting minutes and look at the November 21st, 2017 meeting. So who was present at this meeting?
At this meeting, it was Keith Niven, Patrick Mullaney, Gary Young, and myself.
And was this the meeting that you referenced a moment ago as a follow-up to the dispute resolution letter?
Yes.
What did Director Niven have to say about vesting in this meeting?
He told us that right now, site development preliminary land use applications vest to the development agreement, and so that we are vested to the development agreement.
And so can you, actually, I think I see where you were referencing in your notes. Can you read those two sentences that you just paraphrased into the record, please?
Sure. So it said, my notes say, right now, SDP prelim apps vest to DA. KN, which would be Keith Niven, vested now to DA. Council can decide they don't like vesting language. If council changes their mind, you start over.
So that last part that you just read, what is that referencing?
This was that idea that he had raised earlier, that they had advised council that removal of vested status was a policy decision that the council was entitled to make with respect to our applications.
Is that consistent with your understanding of how vested rights and the vesting doctrine works?
No, that would mean that vesting doesn't exist as a concept, because vesting means that that your right to be considered under the land use regulations that are in place at the time of your complete application survives change of the applicable land use standards. So if the council could change the standards and then also decide to remove your vested status, that would mean vesting didn't exist at all.
If you go to the very end of your notes there, looking at the very last notation that you make on the last page, what was the follow-up from this meeting?
So at this meeting, Keith suggested that because we were asking for confirmation that we were vested to the development agreement, as he had stated, he suggested that I write that in an email to him and that he would confirm via email.
And did you do that?
I did, and he did.
Let's look at Exhibit C4. So, and again, this is in kind of reverse chronological order, so I'm looking at the very last pages first. It's an email from you dated November 21st, 2017. Was that the email that you were just referencing?
It is, so you can see that I sent that right after the meeting that we had, and it references that we had met with him that morning. And it asked him to confirm our understanding that the that our land use permit applications have been deemed complete per Appendix L of the development agreement and are therefore vested to the development standards in the development agreement.
So if we look at that table then that follows in your email, what is the table showing?
The table shows all of the applications that we had in at that point in time.
And were those, it looks like, did this include the plat on this list, or is that a separate issue?
It did include the plat at that time, but the plat was at a different stage because the full application for preliminary plat had already been deemed complete.
Okay, and so these were looks like the SDPs and ASDPs that were at different stages at this point. What stages were they at?
Let's see, my table there shows when they had been submitted. So we had a preliminary application for SDP for the medical office, which was submitted on 10/23/17. The retail SDP was submitted also on 10/23/17, and the pre-app for the office building was submitted on 11/9/17.
So what was the response that you received to this email?
So the initial response from Mr. Niven was just, it stated, unless you have received a request from the city staff for additional information, these applications are viewed as, quote, complete, end quote, per the terms of the development agreement. And I followed up on that. Again, this is all on the same day, and said, thanks, Keith. We have not received any request for additional info. I'm assuming that you mean that the applications are complete and vested to the development agreement as stated in the email below. And as we discussed in our meeting with you today, please confirm. And then his response to that was yes.
So then there's a follow-up chain. It looks like that last email was from Keith Niven to you with Gary Young and Patrick Mullaney and Lucy Sloman copied. But then the next email, who's that between?
Then the next email is from Lucy Sloman to Keith Niven, and she says, they aren't vested unless the council agrees to the vesting language. I'm confused.
And what was Director Niven's response?
His response was, they are vested at this moment under the DA. If the council removes the proposed vesting language, they will lose their vested status.
And what did Ms. Sloman say in response?
She asked Mr. Niven, shouldn't that be clear in the response?
Did Director Niven or Ms. Sloman ever tell you about this email chain or tell you anything about the content in terms of asking for clarity or providing clarity in a response?
No, the first time that I saw this was in this hearing.
And in that email where they're discussing, where Director Niven says, if the council removes the proposed vesting language, they will lose their vested status. Is that consistent with your understanding of how vested rights and the vested rights doctrine works?
No, because again, you would be suggesting that legislation could be retroactively applied to remove vested status of applications, which is very clear from the case law in Washington State that that is not something that can be done. It also would be suggesting that the vesting language that would apply to our applications did not yet exist, which is kind of an absurd concept.
So about this time, November 21st of 2017, was Shelter continuing to work on its SDP submittals?
Yes, I believe that our full SDP applications were submitted around this time, or at least the first couple.
Okay, and so, so we're going to walk through a couple of those submittals again. So the first one that we're going to talk about is the medical office building, which I'll represent was November 21st, 2017 for the final submittal. Is that consistent with your understanding?
That sounds right to me.
So this would be, the next packet is going to be S62, and we're going to have subparts to that as well.
If I could make a suggestion, it's been an hour, perhaps we could take our break and then we could put all of the subparts together and hand them up at once at the conclusion of the break and save a little time that way.
That's an excellent suggestion. We appreciate that. So let's take that 10-minute break. Thank you.
Thank you.
Okay, we're back on the air. Ms. Carey,
Thank you.
please proceed.
Right, so we compiled S62 and there's subparts A through E, which Tia has in front of her now. So Tia, will you move through and just starting with S62A, describe what that is, please?
So this is the medical office building site development or administrative site development permit submittal. So S62A is sort of the bulk of the package. So it has, you know, the project information and various graphics. It has site views and off-site views. Again, the natural and man-made features around the project, site access opportunities and constraints, site views along the frontage. It has parking layout and tabulation and summaries of the parking both in the structure and on the surface. It has a graphic that shows where a potential Phase 2 building could go. It has building elevations. From various sides of the building. What is this? It addresses things like fire truck access, floor plans, interior floor plans. Again, more elevations and materials that might be used. And then it has views of each side of the building and the proposed parking structure. It has a grading and storm drainage plan. It has utilities addressed. It has a context map that shows how it fits into the larger community. It has various calculations and landscaping and images and plant selections, and it's an extensive package, but that's what's part of the site development permit submittal requirements.
And how about at S62B?
S62B is an update to the title commitment or subdivision guarantee. And S62C is a letter from the IHCA Architectural Review Committee approving of our application. S62D is the affidavit of ownership and also the affidavit of agent authority for this application. S62E is Solid Waste Service Company Review and Collection Space Standards form.
So we have a lot of documents in each of these packets. Are they necessarily all-inclusive, like every single document, or are there other submittals or other documents that might have been submitted with those applications?
This looks pretty comprehensive, but I know that there was one document that we submitted with each of our site development permit applications that was, I think we called it a SEPA statement, and it basically referenced the development agreement and the fact that the SEPA had been completed in connection with the development agreement, which was why there was no SEPA checklist required. So I know that was submitted, and I don't see it in this package. So there may have been other items like that that aren't here, but this is the bulk of the site development permit packet for the medical office building.
Thank you. And then right around that time, were you also moving forward with the retail submittal?
Yes, so the retail SDP submittal and the medical office building submittal were kind of on parallel tracks on relatively the same timeframes.
Okay, and so we have a packet of documents that will be introduced as S63 and then the subparts as well. So starting with S63A, if you could describe that document, please.
So this document at S63A is a site plan showing the proposed retail project on blocks A, B, and a portion of C.
And is that showing the buildings that you were describing yesterday evening in terms of the different buildings that make up that retail project?
Yes. And then S63B is, again, a title commitment or subdivision guarantee that was submitted with the SDP application.
Okay, and S63C?
S63C is the letter from the Issaquah Highlands Architectural Review Committee approving the retail application packet.
And S63D?
S63D is a geotechnical report for the property prepared by Terra Associates.
And just as a note on there on the geotechnical report, it refers to the High Street collection. Is that the same thing as the retail?
The High Street Collection is actually the name that we use to refer to the entire plat. So we would use that to refer to all of our proposed projects up there. So yes, it would also be inclusive of the retail.
Thank you. And then finally, there's S63E.
S63E is the affidavit of ownership and affidavit of agent authority.
And I apologize, I said finally, but there's actually quite a bit more to this one. So that was S63E, so we're on S63F. And what's this document?
S63F is a solid waste service company review and collection space standards. And this one was prepared for the retail.
And then S63G.
So S63G is a memorandum from Transpo Group, our transportation consultant, that addresses blocks A, B, and the north half of C.
And S63H. And this is something, is this document at S63H, is that specific to this application, or is that general information? Can you just describe what it is?
This is some kind of city form on site development permit applications. I'm not exactly sure where this comes from.
Okay. And then S63I.
Oh, you gave me an extra one, I think.
Yeah, there's one extra here for you.
S63I is a land use permit application form for the site development permit for the retail project.
Okay. And then S63J.
So S63J is sort of the bulk of the application. Again, has site plans, views from in and around the property, circulation plans for both vehicular, pedestrian, bicycle, fire department access, and fire hose reach analysis, and then provides sort of zoomed-in plans of each block. Building elevations, and this one is a big one because there are, I think, 11 buildings in the retail proposal. Engineering and grading and topographic information, stormwater layout, cut and fills, landscape plans, more landscape plans, more landscape plans, pretty extensive landscape plans, actually. And all sorts of images, the plant schedule that would be used for the landscaping. It's
Okay.
a thorough packet.
And then S63K.
S63K is project narrative. See if there's any, and design criteria narrative, including landscape guidelines.
Okay. And then S63L.
S63L is the SEPA envelope determination, which I referred to earlier as a SEPA statement, and we submitted this statement with each of our site development permit or administrative site development permit applications.
And that's what you were referencing earlier?
Yes.
Okay. Okay, and then S63M.
S63M is the preliminary stormwater report for the retail blocks A, B, and C, or C North.
All right. And S63N.
So S63N is the site development permit submittal requirements checklist, and it has items checked off, and it has a few notes on it with respect to where information is located or available.
Okay. And then finally this time, and I think I mean it this time, S63O.
This looks like it's a form generated out of mybuildingpermit.com, which is the online building permits, or I guess just permit submittal program that the city uses. So I assume that this was generated by the information that our applicants are our consultants rather, uploaded to the city's mybuildingpermit.com website to submit this application.
Okay. Do you recall roughly when you had a pre-application meeting for the retail and medical office building?
I know that from the time we submitted our preliminary land use application, which was what you had to do before the city would allow us to schedule those meetings, it was, I think, 5 or 6 weeks out. So one of the applications, we had the pre-application meeting right before we submitted the full application, and the other one, I think we may have submitted the full application right before having the pre-application meeting.
It was roughly around the end of November 2017. Does that sound accurate?
Yes.
Okay. So I'd like to turn now to C16, Exhibit C16. So it should be in that binder in front of you there. What is the document at C16?
This is one of the letters that we received with respect to our medical office building SDP submittal, where the city deemed that it was insufficient, our application was insufficient.
And so this is in the subject line, it says sufficiency determination. Is that how the city typically refers to these, as sufficiency determinations?
I know that that's how they referred to the letters that we received on these applications.
And so we don't have to go through every point in this letter. It speaks for itself. But in general, well, first of all, did you get multiples of these letters for your different project applications?
Yes, every time we submitted, we got an insufficiency determination back from the city in just under the 10 days that, I guess to back up a step, according to the development agreement, if you submit an application, the city has 10 days to review and let you know if anything is missing from the application so that you can then submit that additional material. If they don't respond asking for additional materials within that 10 days, then the application is deemed to be complete. So in each case, every time we submitted our complete application, we would get a letter from Ms. Sloman, usually on the 8th, 9th, or 10th day, stating that the application was incomplete. It became quickly apparent to us that she did not intend to allow us to reach the complete application determination for these applications.
Why did that become apparent to you? Can you give some examples?
Sure. I mean, the most obvious and troubling example was that one of the categories of objections that she repeatedly made was that we could not meet the requirement of showing things like lot lines because our plat hadn't been approved yet. And at various times, she either said that the preliminary plat had to be approved or that the final plat had to be approved, which seemed to make absolutely no sense to us, since a final plat approval could be years down the road, and the idea that you couldn't even submit an SDP for processing until that occurred really made no sense. But there were, I guess, several categories of things that she objected to. I would probably put them into 3 major categories. One were things that related to the plat, so things that she said we couldn't possibly have because the plat wasn't approved. Now, keeping in mind that the reason the plat wasn't approved was because she hadn't started reviewing it, and we're sitting at the end of November, beginning of December, and she'd had that application since August 1st and had done no review, and it should have been end of October decision by our calculation under the development agreement, Appendix L. So the plat was the big category, the things related to the plat. There were a number of items that she asked for on various applications and in several of the insufficiency letters where information actually was already provided, but I think her review was happening relatively quickly in order to kick the applications out under the 10-day time frame. And so she would say, I need this information or that information, which was already provided, and we would point that out. And then the last category, I would say, are things that were just very nitpicky, and I don't think are things that would typically be called out by the city as a basis for deeming an application incomplete. So there was definitely crossover happening in reviewing aspects of the application that would be reviewed in the review phase and not in the complete application phase. So I guess to go back to C16 and look at some of the comments. So for example, the first comment where it says almost every document that was uploaded was mislabeled, making review difficult. Well, that had to do with the way the city's system is set up, and the staff, the permit technician at the city had advised our consultant, if you don't have the category to choose from in my building permit that matches what you're actually uploading, choose something else that's close and we can fix it. So that's what we did, but then we got kicked out, and that is one of the reasons given for that. Number 2 on this letter, it really relates to the plat and the sort of endless loop that we would never be able to get out of because she controlled the very thing that we need, according to her, to get to complete application. Number 3 was something where, no neighborhood type is provided on the cover sheet. Well, it was provided on the second page. So it was maybe in the wrong place according to the permit checklist, but the information was there. Let me just quickly scan through some of these. Oh, number 5 was another one that we really struggled with how to address this. So one of her comments is, existing site survey includes roads which do not exist. Now, what was actually going on was that there are roads that Polygon at the time was in the process of constructing on a portion of our property and adjacent to our property. The roads did exist, like you could walk on them, drive on them, they were there, but they hadn't been accepted by the city. So she was asking our survey to not show things that were physically there because they hadn't been accepted by the city as complete. As you might imagine, for a surveyor who's supposed to go out and look at what's there and depict it on a survey, they struggled with how would they go back in time and show what was there before. So that was another one that just seemed not reasonable.
Okay, and then how about, let's look also, because around this time there was a letter for the other application as well, so it'd be C17 would be the next exhibit.
Mm-hmm.
Can you describe what this is?
This is a similar letter, but it is for the retail application.
Okay, and you had mentioned on the last one, the issue with the plat. In subsection 5 there, can you maybe, without reading the first full sentence there that has a lot of jumble in it, kind of paraphrase and then read the second half of that paragraph to us?
So it goes through and lists a lot of things like property lines and right-of-way and distances that buildings would be from property lines. and it says, "These elements do not exist at this time. The request is to process a site development permit, or SDP, prior to completion of the platting process. Provide the basis for determining a complete application without this information. In addition, explain how the process would proceed, given that approval conditions, notes, and restrictions, easements, etc., would not exist for use in the review of the SDP."
So, and is that the same comment that you got in response to the medical office building?
Yes.
And then before we move on from this one, is there anything else that, again, we don't have to march through everyone piece by piece, but anything else that you want to highlight in this one?
I mean, like number 17, above grade utilities, power vaults, et cetera, are not shown, nor is the relationship between utilities and plants. I mean, that may be something that she would want to work through in the SDP process, but that seems pretty extreme to be a basis for deeming an application complete.
Okay. So moving forward in time, do you recall when the storage application was submitted? And we're kind of in the chronology of things, we're roughly towards the end of November of 2017 right now.
I don't recall off the top of my head.
Okay. If I said December 1st of 2017 for the preliminary application, does that sound accurate?
Yes.
Let's turn now to Exhibit S32. What's the document at S32?
This is a December 4th, 2017 letter to the Issaquah City Council from our attorney, Patrick Mullaney.
Did you also receive a copy of this letter at this time?
I did.
And if you go down to the third paragraph there, it starts with, "As Keith Niven pointed out." Can you just read that first sentence?
Yes, it says, "As Keith Niven pointed out in the vesting memo, attachment 4 to the November 17th, 2017 staff memorandum, the city requires issuance of a land use permit, e.g. site development permit, as a necessary prerequisite to issuance of a building permit."
Is it your understanding that that attachment 4 that's referenced in this letter is the same November 16 memo that we were talking about earlier that describes the West Main problem?
Yes, it is.
So, and you had mentioned earlier in your testimony that Director Niven would have had many opportunities to correct his so-called error, if that was the case. Did he correct that error at this time after receiving this letter?
No, he didn't, and neither did the city attorney or anyone else in the staff.
We've got a couple new exhibits to introduce at S64. Okay, so we're looking at S64. Can you describe what this is, please?
This is the supplemental submittal that we made to our plat application, I believe on December 15th, 2017.
And my notes say that the date was December 12th of 2017, so it might just be a few days different.
That could be right.
Okay. And so what do those show?
So these show the building footprints that were proposed in the site development permit applications on the plat application. So part of why we did this was the comment in the insufficiency letter that we were talking about, where, you know, Lucy was giving us the feedback that she couldn't understand how the site development permit applications related to the plat, because the plat hadn't been approved. So we did what was in our control, which was to put the two together so that she could see the setbacks from the lines and everything else. And we submitted that as part of our application for the preliminary plat. And so we did that both by uploading to mybuildingpermit.com as part of our application, and also by sending it directly to our planner, Jean Lynn, so that she would be aware that we had made that supplemental submittal.
So you said that this was a supplemental submittal. Was there anything really changed about the plat application at this point, or was it just clarification?
There weren't any significant changes. A few things shift around a little bit, but nothing significant. It's still the same.
So let's take a look at Exhibit S3.
Oops. Yes.
What is the document at S3?
So, S3, oh, this is the notice of application and that the city issued, and they did our plat application as a joint notice of application with two of the adjacent polygon applications. So the first couple pages are for Westridge North single family rather, and Westridge Townhomes North. And then the third section of the notice of application is for our High Street Collection preliminary plat.
Okay, and what was the date of the notice of application?
It was December 27th, 2017.
Who prepares notices of application in the city? Is it the applicant or is it the city?
The city staff prepares them.
And specifically on this one, who prepared it?
I would assume that it was Jean Lynn, since she's our planner, but I don't know that for sure.
If you look at the attachment to that notice, what does the plat show on the diagram that was attached to the notice of application?
Oh, the diagram that's attached is the December 2017 supplemental submittal. So it shows the site development permit building footprints on the plat layout, which I mean, made sense to us why you would choose that application or that graphic, because that would be the graphic that gives the most information to the public, and that's the intent of the notice of application.
When, around this time or at any point, did the city ever question you or reach out about the supplemental submittal of this plat?
No, it always has been part of our application, and I was actually kind of surprised in the context of this hearing and some of the related legal proceedings to hear the city attorney explain that they somehow don't consider this part of the application because we've never been informed that it wasn't accepted or that it wasn't part of the application or anything unusual with respect to the supplement.
When was the first time that you heard that that might be the position of the city now?
It was either in this hearing or it was in Mr. Lell's briefing to the hearing examiner on one of our appeals of the vesting determination that we sent to the hearing examiner.
I'm going to introduce a new exhibit, S65. It looks like the top is printed off, but can you make out or explain to us who you understand to be on this email at S65?
It looks like it was to Jean Lynn with a copy to Valerie Porter, and it's from Lucy Sloman.
Do you know who Valerie Porter is?
I believe she's a planner with the city of Issaquah.
And what did Ms. Sloman have to say to Jean in this email?
She told her that she did a great job of getting out the combined notice of application for the 3 permits, the Westridge North single family, the Westridge North townhome, SDP, and the Shelter High Street plat.
And what was the date of this email?
This was February 10th, 2018.
So how long after that notice of application showing the building footprints went out was this?
A month and a half.
And you hadn't heard anything from the city questioning the supplemental submission at any point?
No, I mean, I still haven't, other than in this hearing, which is not directly on the plat. So I'm a little baffled by the conversation that we've heard here and seen in legal briefing. Because typically, if you submitted something on your application after the fact that the city deemed to be a major change to your application, they would tell you that it's a major modification and kick your application out or back to the starting point. We didn't get that. We didn't expect that either because we really weren't changing anything significant. And the fact that, 2 weeks later after we submitted it, they used it in the notice of application, just confirmed our understanding that they were processing the plat and that this was a piece of it.
Let's turn back to the meeting minutes and look at the December 12th, 2017 meeting, please.
Okay.
So so first of all, who attended the December 12th meeting?
That would be Lucy Sloman, Jean Lynn, Doug Schlepp, David Holmes, James, can't remember his last name, from Collins Warman, Alan from Hewitt, who is our landscape architect on that one, and Riley from KPFF, our engineer, and myself.
Okay, and what was the purpose of this meeting?
This was the Block C, which is the office proposal, preliminary application meeting.
Did Ms. Sluman, I'm sorry, so I noticed that you said Jean Lynn was there, and she was the planner on all of the applications, is that right?
Correct.
Did Ms. Sloman frequently come to the meetings with Jean as well?
Yes, typically she did. I can only think of one meeting on the plat that she did not.
Okay, so this meeting was on December 12th. And then I'll represent, just so that we can keep things moving along, that on December 20th of 2017 was the retail resubmittal. We mentioned a minute ago that there was the insufficiency letter, and so a resubmittal on December 20th. So we have a couple documents related to that. So this is going to be S65 and its subparts.
I think that's going to be S66.
Oh, yeah.
Oh, no, you're right. Thank you very much for the correction. So S66 and subparts. So this is S66A. And we can move pretty quickly through these. It's just the application packet. So what's S66?
It is a retail site plan.
Okay, and S66B?
Is an affidavit of ownership and agent authority.
S66C?
Solid Waste Service Company review and collection space standards.
And S66D?
This is a land use permit application form for a site development permit for the retail application. E.
All right, and then S66E?
So S66E is a letter from MG2 to Ms. Sloman responding to her comments in the insufficiency letter that we had received.
And S66F?
This appears to be sort of the bulk of the package with all of the plans, elevations, images, engineering.
S66G?
This is the project narrative.
S66H?
This is the site development permit submittal requirements. So it's the checklist, and it's annotated to show what was included.
Okay, and that should close out Exhibit S66 and its subparts. And so just to clarify for the record, all the documents that we just went through, what were those related to?
The retail SDP application.
And so that was that a resubmittal?
Yes, that was in response to the insufficiency letter that we had talked about just a little while ago.
Okay. Let's look at Exhibit C18 and C19. Okay, so what's at Exhibit C18?
This is another insufficiency letter from Ms. Sloman, and C18 is related to the retail project.
And again, we went through your summary in terms of kind of categories of issues that were being raised in the sufficiency letters already. If you look down at number 5 on this one, what was the response to, or what was Ms. Sloman's and Jean Lynn's response to the corrections that you submitted trying to address number 5?
So her response to number 5, which was related to the plat, states, revision is insufficient. As indicated above, without approval of a preliminary plat, these elements do not exist and have been manufactured to meet the SDP requirements. Without approval and recording of the plat, these elements have not been confirmed or vetted. The purpose of the platting process is to review, studies, and establish the property lines as well as other site elements. Without completing that process first, a statement saying you will comply with plat conditions is aspirational. In fact, the plat might invalidate part or all of the site configuration proposed in the SDP, requiring a minor or major revision to the SDP. The proposed process is circular.
So is that the endless circular process that you were alluding to earlier?
It is. I think we saw it slightly differently, circular in a different way, but yes, that's what we're talking about.
So what's approval of a preliminary plat mean? What does that look like in the steps of a plat process?
So approval of the preliminary plat would be the next step after submittal and review. You submit, you review, and then you approve. Then, as I described, I think last night, the infrastructure of the plat gets built before the final plat is recorded. So she both refers to approval of a preliminary plat, but then she says without approval and recording of the plat, which would be much further down the line. So when she references recording, now I'm thinking, well, she's saying I can't get to complete application for years down the line. So this condition was obviously very concerning. And again, the biggest problem with it was that the thing that she says I need, approval of the plat, is the thing that only she controls. I have no way of making her review my plat. It's been in since August 1st, and at this point, we're December 27th, and I haven't received a single comment. She's told me that she doesn't have any intention of following the timeframes in the development agreement, which actually, just before this letter came out on the 27th of December 2017, I received an email from Ms. Sloman asking me if I would give her additional time to review our resubmittal to see if she would deem it complete or incomplete because she was out of town or because of the holidays. I can't remember what the exact reason was. I thought that was an unusual request since they were at the same time taking the position that Appendix L timeframes didn't apply when it came to the review timeframes that they were supposed to follow for review of our applications. Now, when there was a review timeframe that had the clear result of deeming our application complete, she was actually acknowledging that they applied and asking me to extend that deadline. Before I ever responded to her, she went ahead and issued these insufficiency determinations.
Let's look at Exhibit C19.
And C19 is a similar letter of the same date, but it's for the medical office building SDP submittal.
Does the same issue with the plat show up in this?
It does.
And then down on number 11, because you had mentioned it before, the comment on above-grade utilities, power vaults, et cetera. What was the response to the revisions that you submitted?
She says, response indicates this will occur in the future, but must be reviewed during land use permit. No information on the relationship of trees to utilities.
So, and what's the problem? What's the disconnect happening there?
Again, we're getting into review comments instead of complete application comments. And we're just getting into a level of detail that I, quite frankly, have never seen in a complete application determination. And, you know, our project teams collectively for all of these applications have extensive experience both in Issaquah and throughout the region, and we're pretty blown away by the responses that we were getting and the nitpicky things that we were being called out on for complete application.
So, and the nitpicky things, I mean, is nitpicky just annoying that you have to go back, or what's that preventing you from getting to?
It's preventing us from getting to complete application determinations, which are significant because of vesting. Now, we already had confirmation that we were vested from at the preliminary land use application, but from our perspective, both because we actually want to build these projects and from security of vesting in a city that was putting forth as an option at this point some positions that we didn't think were legal with respect to vesting, the further advanced our applications were, the better. So, you know, it was clear that the intention was to keep us from getting to complete application, because these kinds of things, I mean, on here you've got she wanted retaining walls and waste enclosures called out. Well, there's not any significant retaining walls on that site for retail, but you know, there are some smaller ones that you would have in any development. And so we went back and we called those out, and then we were still insufficient, and she's saying we needed length, height, color, materials, and top and bottom spot elevations, which weren't provided. So we're providing information on where the wall is and how big it is, and then she's like, well, but you need the materials. I mean, we're just getting into a level of detail that is not typical for complete application. And we were by no means saying that those were not discussions that we're going to have, but those were discussions that you have in the context of your project review. And just by deeming an application complete, it doesn't mean that the city can't ask for more information later. It doesn't mean that we can't submit more information later. It just means that we submitted enough information for our application to be considered. And that clearly wasn't the standard that was being applied to our permits.
And how about on number 13 there, there's a response to your revision that references platting. What was the deal there?
So that one was Discovery Drive not complete, and the information provided does not clarify what frontage improvements are required for full build out and what dedication might be necessary to do that. And then she says that that's part of the platting process. So this was one of those that she flagged as items that couldn't occur with the site development permit because it needed to happen with the platting process. And with respect to the lot lines that are called out in, I think it's number too on this one. It's also significant when you look at our site. I mean, yes, we're processing a plat, but if you look around our property on most sides, it's bordered rather by right-of-way. So it wasn't as if you're platting a piece of property that it doesn't have established boundaries. It does. And the roads, 2 of the roads that go through our plat are actually already constructed, and at this time were already approved to be constructed or actually were constructed by Polygon. So I think it's even more of a stretch to say that you couldn't deem an application complete without the plat being approved.
So throughout this process, we've been talking about the sufficiency letters, which are these formal letters that we've been looking at. Did you also get comments back from the preliminary application meetings that were held?
We did. They were a little out of sequence because they took so long to issue those comments with respect to the site development permits. So I think I called out when we were looking at our preliminary plat application materials last night that the time frame for issuing the comments after our pre-application meeting was relatively quick. I think it was a week or so after. I'd have to look at the dates again, but I believe we were more like 6 weeks out from pre-app to providing the comments with respect to the SDP applications.
So then, moving forward again in time, we received these insufficiency letters. Did Shelter resubmit applications again for medical office and retail?
Yes, every time that we received an insufficiency letter, we would gather our consultants and try to address everything in those letters and resubmit as quickly as we could.
I think given the time right now, and the next couple are going to be really big packets again, it's probably a good time to take a break, and we can try to gather those together to be as efficient as possible.
Excellent. We appreciate that. Let's take a 10-minute break.
Thank you.
Oh, you should. You should. He talks about.
All right, if I can call the meeting back to order, I think we're on the air, or I know we're on the air, so Ms. Carey, if you could carry on.
Thank you. So first of all, Tia, we have a rather large exhibit coming in, and just to kind of explain the context for this. So we're talking about the medical office building and retail resubmittals. When Shelter did the resubmittals, what did those look like?
I guess at various times of resubmitting, they looked slightly different. But initially, the resubmittals, when we would get an insufficiency letter, we would have to resubmit pretty much the entire package. So that's why you see the 6 inches plus of documents sitting there. We would have to have our consultants reassemble the entire package and resubmit it through mybuildingpermit.com. At the later stages of the insufficiency letters, they identify that the only issues left are the plat-related issues. So there really wasn't anything by way of revising plans or documents that we submitted that could be actually resubmitted. And at that point, then we weren't making full resubmittals. We were making like a letter of resubmittal.
So we've tried to figure out the most efficient way to do this. And so I think we're just going to run through as we have been in terms of saying, you know, the full exhibit number. In this case, we've moved through to S67 for the medical office resubmittal. Tia is going to go through and identify the documents just so that we understand what they are in the record, but we're going to move through them as quickly as we can. So we'll start on that process. So this is S67. The first one is S67A. Tia, if you could describe that document just briefly, please.
This is a title commitment or subdivision guarantee.
Then S67B.
This is the ARC approval letter for the retail project.
And S67C.
S67C is the affidavit of ownership and the affidavit of agent authority.
And S67D.
S67D is the geotechnical report.
S67E.
S67E is the preliminary stormwater report for the medical office.
S67F.
S67F is the Solid Waste Service Company Review and Collection Space Standards form for the medical office.
I got slashed by a staple, I don't want to pull it
Oh.
Stops the flow. Okay.
You okay?
We're good.
That's right.
Counselor?
Okay.
Counselor?
I'm sorry?
Care for a Band-Aid?
Oh, if it keeps bleeding, yes, thank you very much.
Ah, you're prepared. Wow, really?
At risk of harming you, we'll continue on. Okay, so this is S67G.
S67G is project narrative for the medical office, ASDP.
S67H.
S67H is the land use permit application form for the site development permit for the medical office building.
S67I.
S67I is the Transpo Group memorandum regarding the Block D medical office building. And I think some of these may be showing up in resubmittal, and they were probably actually submitted with the original application, but their file may have culled them out and put them in the resubmittal, the filing system of the consultants.
And S67J.
This is the public notice site plan for the medical office building.
S67K.
This S67K is the SEPA envelope determination. I can't tell for sure which application that goes to, but it was submitted with each of our applications.
S67L.
S67L is the site development permit submittal requirement checklist.
S67M.
S67M is the medical office building site development, administrative site development permit resubmittal, and it's the main package of plans, and it's dated January 16th, 2018.
S67N.
S67N is an existing conditions sheet of the submittal, of one of the resubmittals for the medical office building.
And then S67O.
S67O is a January 17th, 2018 response to the ASDP insufficiency letter for the medical office building. And the cover page of this is a printout from my building permit that is an attempt to respond to one of the previous comments in the insufficiency letter about not being able to tell where various documents were submitted. So it's sort of a map that shows, for example, our storm report is under the title drainage report, or it's the road map to show where specific documents are in my building permit. Oops.
S67P.
S67P is a January 17th, 2018 ASDP submittal response letter to Lucy Sloman from Collins Warman. And that's on the medical office building.
S67Q.
S67Q is a January 17th letter to Jean Lynn regarding this is responses to the pre-application ASDP comments on the medical office building. So those were included with one of the resubmittals because we didn't have comments yet at the time that we made the submittal.
S67R.
S67R is a transmittal memo to Christopher Wright at the City of Issaquah from David Holmes regarding the medical office building, and it's dated January 17th, 2018. And it lists the various items that are included in the resubmittal.
Okay. I think that should close out S67. So we also had, around this time, the retail resubmittal. Is that consistent with your memory?
Yes, as I mentioned before, both those were sort of tracking along very similar timeframes.
Okay, so these are going to be at S68. So starting with S68A.
S68A is a site plan for the retail SDP.
S68B.
S68B is a letter dated January 16th, 2018, addressed to Lucy Sloman. Responding to one of the insufficiency letters with respect to the retail application.
And S66C, or sorry, 68, rather, C.
S68C is the bulk of the package of the retail site development permit, so all the maps and plans and elevations and photos and images.
Okay. So that should be the end of S68. Let's turn to Exhibit S6 in the record, please.
Okay.
Can you describe what is the document at S6?
This is the summary of the various applications, of our various applications that I believe was prepared by Lucy Sloman.
Okay, and so there's summaries of the different dates, it looks like. She's listing out different dates of things like the pre-app, the collaboration meetings, and then also there's a list of dates for, it says insufficient, and then followed by dates there. Are these dates on this chart consistent with your recollection of when the various dates for your applications were?
I think generally, yes. I would make a couple of comments to that. The first is on the preliminary plat. It notes that we got comments on January 16th, 2018. I don't think that's accurate. I think that a comment that ended up relating to a change in something that they asked for with respect to the plat came out of the review of one of the other SDP applications, but we didn't receive any comments on the plat until March of 2018. The other thing, I guess, I just don't know what the comments mean under where it says comments and gives a date for each of the SDP applications. I'm not sure what that means. I don't know if those are pre-app comments. They might be the dates that we received the pre-app comments. But we never received any application comments.
So pre-app comments, what are those?
Those would be the comments that we get out of after a pre-app meeting. So you have the meeting, you have discussion about the application, and then the city generates written comments that come from various departments within the city and consolidates those into a letter and sends it to you.
And so then is that distinct from the insufficiency letters or sufficiency letters that you're receiving?
Yes, that's different.
So according to this, when was the first date that comments were received, assuming that we're talking about pre-application comments, on the office pre-application and retail pre-application?
When you say office, do you mean the medical office or the office?
No, the office.
So this chart notes that office comments were received January 16th, 2018.
And so how long after submittal of, or how long after the pre-app was that for these different applications?
Well, on this, it says that the office pre-app was submitted on November 9th of 2017.
And
So
so
2 months,
2 months.
a little over 2 months. And then retail has comments noted as January 16th, 2018, and the pre-app was submitted on October 23rd, 2017. So that one's even longer.
Okay. Let's turn to your meeting minutes again and look at the January 17th, 2018 meeting.
Oops. January 17th?
Yes.
Okay.
So what happened at the January 17th, 2018 meeting? What was the purpose of that meeting?
So that was the pre-app meeting for our storage administrative site development permit application.
And then let's turn, and actually before we move past that, we're going to have a new exhibit at S69. And I'll represent that these will be documents related to the storage pre-app, and Tia, you can verify that for me as we go through.
Okay.
All right, so the first one that we will have at S69 is S69A. And Tia, will you please describe that document for me?
This S69A is a letter from Jackson, Maine Architecture, which was our main consultant and point of contact for the storage application. And it looks like this is a cover letter that goes with the submittal.
And then S69B.
S69B is the main submittal for the storage pre-app, and so it has the existing site information, all the different views, similar to the other applications that we've already gone through. It has site context and adjacent uses, and what is this? Some kind of sunrise sunset analysis. I'm not sure what that is. Neighboring developments. It shows some engineering work, building massing, architectural concepts, building inspiration, landscape inspiration and plant palette, architectural concepts, and a written narrative.
And how about the document at S69C?
S69C is the land use application form for the self-storage.
And S69D?
S69D is the land use permit application form for the preliminary land use application for the storage facility.
Okay, so that should close out S69. And let's turn now to, well, and actually before we move on, so you walked us through what those documents are. So were those related to the pre-application for self-storage, is that correct?
Yes, those would have been the submittal that we made prior to being allowed to schedule the pre-application for storage. And when we were doing the storage application, we asked again, could we go without a pre-app and go straight to application? And again, we were told, no, you need to do the collaborative and pre-app.
Okay. Let's turn to Exhibit C20. What is the, oh, sorry, I'll give you a minute to get there,
Okay,
Tia.
I'm almost there.
No worries.
Okay, I got it.
What's the document at C20?
So this is a January 26th, 2017 insufficiency letter from the city on our retail proposal.
Okay, and going down to number 5 in that sufficiency letter, what did the city have to say, or what did Ms. Sloman have to say with respect to the plat issue that we've been discussing on these applications.
So the January 26th response says revision is insufficient. Letter agreement has not been approved by the city attorney and signed by both parties.
What's the letter agreement that this is referencing?
So it's referencing the letter agreement that was ultimately signed in March, I believe around the 16th of March, or it might have been the 18th. The 16th or the 18th of March 2018, it was actually signed, and it acknowledged that our applications were complete. So the reason why it's referenced here at this time in late January is that is a letter agreement that Patrick Mullaney worked on with Lucy Sloman, and it had been sent to the city for review and signature. So when she says it's not been approved by the city attorney, at this point we didn't have any comments or response from the city attorney or the city staff, but we had sent over, I believe, a signed version at that point.
What was the point of that letter? Why were you pursuing that?
The reason why we were pursuing it was the endless loop of plat requirements for completeness. There was nothing that we could do absent entering into some letter agreement with them to get across the finish line that Ms. Sloman had established for us, which was a line that couldn't be reached until she completed her review, approval, and potentially of the preliminary plat and potentially of the final plat. So we had engaged in discussion with the city to try to figure out what really was the concern and how do we get there. So one of the things that's addressed in that letter is that they're supposed to review the plat first, and they were supposed to review the plat, I forget what the terminology is, but quickly after the letter agreement.
So let's, I'm going to introduce a new exhibit S70. What is the document at S70?
This is a letter dated January 31st, 2018, and it is from me to Lucy Sloman and copied to Keith Niven, Jim Haney, the city attorney, and Patrick Mullaney, our outside attorney. And it has to do with this this issue of how do we get to complete application when you're controlling the one thing that's preventing us from getting there.
And so as you go through this letter in the third paragraph down, can you read the first sentence of that paragraph, please?
Of the third paragraph?
Yes, it starts with unfortunately.
Yes. It says, unfortunately, this is just the latest example of the city's pattern of delaying and obstructing our ability to get to complete SDP application. As you're aware, we submitted our plat application on August 1st, 2017, 6 months ago, and it was deemed complete as of August 11th, 2017. The plat application is required to be reviewed according to the terms of the development agreement.
And so you go on there, that just so you don't have to read the whole thing into the record, can you paraphrase kind of the rest of that?
It basically goes through the timeframes in Appendix L and states that the council action should have taken place by October 28th, 2017, and that we had an expectation that our preliminary plat would be approved in that time frame.
Okay, moving down onto the second page there, can you read the sentence, the top line that starts with "you informed us"?
You informed us on multiple occasions that you were aware of the development agreement provisions but had no intention of following the timing requirements, and that there were no remedies available to us for your failure to adhere to the terms of the development agreement. The city's failure to follow the terms of the development agreement has caused the issue that you are now citing as preventing us from getting to complete application for our SDP, and is therefore not an appropriate basis for deeming our SDP application incomplete.
In that next paragraph, you go on and to talk about a conversation that you had with Director Niven. Can you explain that for us, please?
Yes, before we went in for any of our SDP applications, we went in and met with Director Niven to make sure that we were going to be submitting them in a format that the city would accept and review. And this was the issue that I think, again, I flagged maybe in last night's testimony, where we weren't sure if the city's preference would be to have individual SDP applications on a block-by-block basis, or if they would prefer to have it all as one SDP application because the plat hadn't been approved. And at that time, Director Niven assured us that doing the individual block-by-block applications would be acceptable.
So you go on throughout the letter to describe the process, and we've talked about some of these issues already. At this time, and I'm now down on looks like the third page, the final page of this document. Can you read the second paragraph there that says, as we have stated before?
It says, as we have stated before, we have spent a significant amount of time and resources, over $500,000, on our pending Issaquah Highlands land use applications. And although the city has acknowledged that all of our pending land use applications vested when the preliminary land use applications were deemed complete, we are seeking complete application status for the SDP, ASDPs as soon as possible.
And so the follow-on to this letter, you had mentioned that letter agreement already, and we'll pull that up and talk about it in a little bit. But is that the March letter agreement the follow-on to this letter in terms of kind of the discussions that were happening around these issues?
Yes, I think that a draft of that letter agreement already existed at the time of this letter. So in the second paragraph of this letter, it references that Patrick Malini worked with you to create a letter agreement outlining the process that you requested. That letter agreement was signed and submitted to you and Keith Niven on January 24th, 2018. However, we still have no response from you other than it's been referred to the city attorney. The city attorney does not return calls from our attorney and has provided no response.
Let's turn back to the sufficiency letters that we were looking at a minute ago. I'm specifically looking at C21 now. We'd already talked about the retail one.
Okay.
So what is the document at C21?
C21 is a January 26, 2017 insufficiency letter regarding the medical office building.
And if you look at section 2 in that, what was the response to your revisions regarding the plat issue?
I think it's the same response as on the previous letter for the other project, and it says, revision is insufficient, letter agreement has not been approved by the city attorney and signed by both parties.
And if you go down to number 13, we mentioned number 13 already before in a prior sufficiency letter. Had any change occurred in regard to the city's response to number 13?
No, it says see item 5 above, which I'm not sure if she actually meant to see number 5 or see number 2, but number 5 is the issue about whether roads exist when they're built or when they are accepted by the city.
All right, this next exhibit is going to be S71. And what is the document at S71?
This is a February 2nd, 2018 letter from me to the city, attention Lucy Sloman, and it's regarding the medical office site development permit application and request for dispute resolution meeting. This is essentially the same letter that we wrote for the retail one that is under Exhibit S70, but this is for the medical office.
So what was the date of this letter?
This one's February 2nd, 2018,
Do you recall the date of the other letter at S70?
January 31st, 2018.
So in both of the letters, you had mentioned already that there was a reference that we hadn't received any, Shelter hadn't received any response. The city attorney wasn't returning calls, had provided no response. Is that still consistent between January 31st and February 2nd?
Yes, still true.
Let's turn to your meeting minutes for the February 6th, 2018 meeting. So who was at this meeting on February 6th of 2018?
Hang on. So the February 6, 2018 meeting was the dispute resolution meeting that we were requesting in those two letters that we just introduced as S70 and S71. So at this meeting, it was Jim Haney, Lucy Sloman, Keith Niven, Patrick Mullaney, and me.
So can you walk us through what was discussed at this meeting?
Sure.
I think beginning with, it looks like from your notes, one of the first things that was talked about was the plat. What did the city have to say about the plat application at that time?
So they indicated that it was clear that it's vested. And Patrick asked what that means, and they acknowledged that it means that it vests to the development standards in the development agreement. Patrick followed up by asking them to confirm that that includes the regulations and mitigation. And Mr. Haney said yes to the regulations and no to the mitigation, which really made no sense because development standards is a defined term in the development agreement, and it expressly includes mitigation in the defined term development standards. So Patrick pointed that out to Mr. Haney, and he looked at it and said he understood our position, but thought it's not clear.
What discussion did you have with respect to the West Main problem that we discussed earlier that was brought up in the November of 2017 memo from Mr. Niven and Ms. Sloman?
So, again, Patrick asked about the city's position that preliminary land use applications vest in order to avoid a West Main problem, and asked why the administration was now suggesting that a different standard be applied within the urban villages from that would be applied outside of the urban villages, but in the remainder of Issaquah. And I guess maybe a little bit of background is helpful to understand the context there. So this meeting happened on February 6th of 2018. Up until February 2nd of 2018, the administration had been recommending to council that the language in the replacement regulations acknowledge that SDPs and preliminary land use applications are vested to the development agreement when the application is deemed complete. On February 2nd, an email went out from the city saying that due to the change in administration, the recommendation of the administration with respect to vesting had changed. So this was after Mayor Polly had taken office, and the email that came out offered that she would speak with anybody that took issue with the change in recommendation. So the reason why we were asking that then was that what the city was suggesting was that in the urban villages that would now be governed by, would at the point of adoption be governed by the replacement regulations, there would be language in there that would potentially say something other than that. And we didn't know at this point exactly what that language would be because I don't think it had been released yet. But the concept was troubling, that you could have a vesting standard in part of the city that was different than the vesting standard in another part of the city when the process is identical. So if you have a West Main problem on the valley floor, you have the same West Main problem in Issaquah Highlands or any other part of the city. So that's why we were asking about what could you possibly be thinking that that is a good idea. So when we asked about that, Lucy jumped in right away saying that pre-apps weren't required for our applications. And she started saying how we had pointed that out to her, and then the city immediately said, oh yeah, you're right, which was not what happened at all. If the preliminary applications weren't required, we would not have had them. We asked multiple times on each of our applications, but specifically on the storage application, which lagged behind the medical office and the retail, we very clearly asked again and very clearly were told that it was required. So I disagreed with her in that meeting and said, you know, why would we have had them if they weren't required? Clearly, we just wanted to get our applications processed. And her response was that because they were so helpful and a great tool for us, which if you look at if you think about the timing that we just discussed of the pre-applications and when we got comments and when applications went in, they really weren't helpful for us, and they, if anything, kind of slowed down or made the process a little bit disjointed. Well, for sure slowed down because it inserted months of process ahead of being able to submit our applications. So we moved on from that with Lucy telling me that we have different memories. And then talked about what vests under state law. He also, or Mr. Haney pulled out a section of the Issaquah Municipal Code, which references that it shouldn't be deemed to require anything prior to building permit submittal. So then I'll just read out of my notes from there. We pointed out that the IMC is inconsistent with the way the administration runs things, and that their position is the SDP is required before building permit and pre-app is required before SDP. So in order to avoid a West Main problem, vesting occurs at pre-app. Mr. Haney questioned that and looked at Keith and Lucy, neither of whom would speak to that point. At that point, Patrick pulled out the November of 2017 memo that the staff had written, which lays out that position and says that it's the position of not only the administration, but also the city attorney.
And how did Mr. Haney react to that?
Oh, he laughed and said that he was going to give Wayne hell for that, which he's referring to Wayne Tanaka, who was the previous city attorney. I thought that particularly odd since Mr. Haney was actually the city attorney at the time the memo was written.
And if you go down to the bottom of the page there, in terms of the timing of the application processing and everything, what did Director Niven have to say about the timing of the process?
He said that everything was our fault and that staff was trying to get the replacement regulations passed before the end of the year, and we slowed it down, and so now the administration changed their mind, and there's a new mayor, and we have to deal with the consequences. We, meaning IHIFC, has to deal with the consequences.
What did you understand that to mean, that you have to deal with the consequences because of a new mayor?
I understood that to mean that the new mayor was directing the administration to change their recommendation to not recognize our vested applications.
And so just to clarify again, in terms of the replacement regulations, because some of this is happening in the context of those, does it matter what the replacement regulations say in terms of whether your vested rights are recognized under Washington law?
No, it shouldn't. The problem is the way that the staff is interpreting those regulations and trying to apply them retroactively.
Let's turn to the February 7th meeting notes that you have in your binder there. So what was the meeting that happened on February 7th of 2018?
February 7th, 2018 was a community meeting on the replacement regulations and the end of the development agreement that was held at Blakely Hall.
And who was presenting at that meeting?
Lucy Sloman and Keith Niven.
Was it just limited to people from shelter, or was it a public meeting for others to attend?
No, it was open to the public, and the intent was to do outreach to the community to let them know how the replacement regulations had evolved over the time that they had been in consideration by the city.
Do Do you recall if Ms. Sloman or Director Niven had any comments in terms of the development agreement and what it provided for at that meeting?
Yes, that was one of the meetings where Ms. Sloman presented her slide that said that the development agreement provides no guidance or regulations regarding vesting of applications.
Is that true?
No, it's absolutely false. There's a section that's titled Vesting of Development Standards and Mitigation.
Do you recall whether Director Niven had anything to say about shelters projects at that meeting?
He did. This meeting was different than some of the other hearings and committee meetings because there was more opportunity for members of the public to interact and ask questions and follow-up questions. In that context, he referenced that some of the provisions of the replacement regulations were in response to our applications, and when they saw our applications, what they thought they needed to do to prevent the things they didn't want. And he also said the city wants jobs, they won't give up on that, and if we have to wait 10 years or more to build anything on our property, that the city's okay with that. There's video of that meeting that's probably more accurate than my notes as far as the exact things that were said.
Thank you. That's helpful, and you know, a lot of this is your memory too, in addition to your notes. So, okay. So, but your recollection of that meeting, it sounds like, was that Director Niven was specifically referring to shelters applications.
Yes, he made it clear that when they saw the applications that were starting to come in, that they realized they wanted to change the replacement regulations that had been initially proposed to prevent certain types of development that are allowed under the development agreement.
So continuing forward in the chronology of things, we're turning back to the applications themselves, and I'd like to look at C22 and C23. It should be in the binder right there.
There was one other thing on that meeting on the 7th. I know Director Niven had testified when he testified at this hearing that he was not directed by anybody to change his position or change the administration's recommendation with respect to vesting, but at the beginning of that February 7th meeting, prior to the meeting starting, Director Niven was speaking with Gary Young and I, and indicated that he was just following his new boss's directions with respect to the recommendation change on the vesting language.
Who was his new boss?
Mayor Polly.
So let's turn to Exhibit C22. And can you please describe what the document at C22 is?
C22 is another insufficiency letter from the city, and this is on our retail application.
Okay, and so this one, the introduction paragraph looks a little bit different to me. What's changed in this sufficiency letter?
There's some text added that says, however, in summary, The only outstanding submittal requirement items are associated with the pending preliminary plat. There's more if you want me to read it, but that's the in summary sentence. So at this point, on February 9th, 2018, the only issues that are left, according to the city, are the ones that relate to the plat, which at this point, still, they have not done any review on.
So down at on number 5 that we've talked about a couple of times with prior versions of this letter, on February 9th, can you explain what the response was?
On February 9th, it says revision is insufficient. See an introduction above.
So at this point, is there anything else that you could have done to move this application forward?
No, I mean, we submitted the plat, we're asking them to review the plat, they're not reviewing it, so then we try to get a letter agreement, we negotiate the letter agreement, we sign it, we send it in, they don't respond. So we're stuck, and all we're trying to do is get our applications to continue through the process. And we had an expectation that the development agreement, which is the only set of regulations that applied to our project, would be followed, and they're just saying no, and we don't have to follow it, and you don't really have any rights under it to enforce it. So
we've been doing a lot of talking about the replacement regulations that are being drafted at this time, and then there's the development regulations through the development agreement, also called development standards, we've heard you explain. So what's in place at this time while we're dealing with all this back and forth with the city? What's governing?
the development standards in the development agreement that were enacted through the development agreement. Those are the only thing that can apply, because the replacement regulations are not adopted. They're in draft form. They're still being considered. They're still being modified. As of, February 2nd, they say they're going to modify the language. I don't remember the exact date when the modified vesting language came out, but it was even after that. It was even later than that. So there was only one set of regulations that we could follow. We were following them to the best of our ability. We were trying to get the city to follow them. We didn't have anything else that we could do.
Let's look at C23, which appears to be another sufficiency determination. Can you describe this one for us, please?
C23 is a February 9th, 2018 insufficiency letter. This one is on our medical office building. And this one is, again, has this new language that says, in summary, the only outstanding submittal requirement items are associated with the pending preliminary plat.
So stuck on this one too.
Correct.
So I'll represent, and you can confirm for me later that if we're moving forward in the chronology on February 14th, the storage application would have been submitted. But acknowledging that we've got just a couple minutes of time, I'd like to skip over that and come back and address another issue this evening. And actually, before I do that, so we're at 9:52 right now. Were you intending a 10 o'clock cutoff for this evening as well? Okay.
Close to 10 as we could make.
Okay, we'll get through one more topic and then we can end for the evening. So let's take a look in your meeting minutes at the February 15th, 2018 meeting, please.
Okay.
So what was this meeting about?
This was a meeting with Mayor Mary Lou Pauley and Keith Niven and myself and Derek Strait, who is the president of Shelter Holdings. And this was in response to when the city sent out the notice that they were going to be changing their recommendation with respect to the vesting provision that would be in the replacement regulations. They offered that because it was a change coming from the administration, that the mayor had offered to speak with anyone who had issue with it. So we, of course, had issue with it and immediately asked for a meeting with the mayor. So this February 15th meeting was that meeting.
And so at this meeting, did you discuss the West Main issue that we've talked about with the mayor?
We did.
And what happened in the course of that discussion?
So I asked her that since the originally proposed vesting language was based on the current practice and acknowledgement that the city process has issues under West Main, if you don't acknowledge the vesting occurring earlier on in the process, I asked her what had changed in that analysis to support that new position. And she said she didn't know. She didn't know of any new legal analysis that had been done to support the change in position.
Did she say anything about vesting under the development agreement?
She told me that the development agreement is silent on vesting, which I immediately pointed out that it's actually not, and cited to the section that's titled vesting. Keith said we disagree on that. And so I suggested, well, at least we can agree that there is a section of the development agreement entitled Vesting to Development Standards and Mitigation. And Keith said no, that he didn't agree that that section existed. So it was very much an uncomfortable and strange experience for me because clearly that exists. Clearly it existed. He knew it existed, but for some reason we were playing this game that we were not going to agree that it existed. And we were talking about the title, we weren't talking about any content, so it was bizarre at best.
Did you ask Mayor Lou Pauley about why there had been this change, and that we're talking about the replacement regulations specifically, but why there had been a change in the administration's position on what the replacement regulations should say about vesting going forward?
We did, and she said it was something that she had been thinking about a lot, about where the appropriate time for vesting to occur would be. And she said that she had saved a letter from the city attorney from Land and Shore from a long time ago that she felt really supported her position. And so I asked her if we could have a copy of that letter because I hadn't seen any letter like that. And she said, sure, let me run to my office and get it. And so she went to her office and she came back with a letter that was actually from our attorney, Patrick Mullaney, and supported our position and outlined exactly why what she was now recommending was not legal. So again, very bizarre and uncomfortable situation, but that was what happened.
I think we're ready to end on that note for the evening.
Okay. I think we're ready to end too, but there are a few things that we need to reconcile. The first is that we are at the time that we agreed to adjourn, but and we'll continue the public hearings on tonight's agenda to future meetings, future meeting date, but we need to decide on when those next meetings might be. I understand that the parties may be available to continue these hearings to the evening of March 5th and 6th. Is that correct?
Yes, we will have some witness availability issues on the 5th, I believe. But given where we're at in Ms. Himes' testimony and Mr. Lell's explanation that he expects a lengthy cross of Ms. Himes as well, I would expect that we could get through the 5th before another. Is that still consistent with?
Yes, if I can clarify.
It's not me.
Ms. Heim would be here on the 5th of March, and if I could ask, how much longer do you anticipate with your direct examination?
I would expect that we would finish up that evening, but I don't know whether we will take the full time or a shorter amount of time. We're just kind of moving at the pace that we can.
And could you provide some approximate estimate of how many more documents you anticipate entering into the record?
I don't know the numbers, but if you can see the second box right here, it's kind of that remaining stack is what we're looking at.
A half a box.
Half a
Given-
box.
Mr. Chairman, given the sheer volume of materials and the apparent likelihood that Ms. Heim will be testifying for at least a good portion of the March 5th hearing date, if we do in fact reconvene on that date, our request would be that we end that meeting with her direct testimony and begin our cross-examination, which will be lengthy on the following date, just for planning purposes.
Okay, so
We want to use up the whole time.
does that seem consistent with your thoughts?
I mean, we'll use, all the time that we can get. If we end halfway through and there's an ample amount of time to begin her cross-examination, our preference is to continue through this hearing, and use as much time as we can so we get through it faster. But, if they're requesting to end it early, that's the city's request. We would, of course, request to keep going and have them do their cross at that time.
That's what you guys did.
And it would really depend on how far we get into the meeting on the 5th as to whether or not that would be, I think, an efficient use of time. Again, we're talking about a cross-examination of a witness that at that point will have been on the stand for, I believe, 5 or more hearing dates. So there's going to be a significant volume of information to cross-examine her on, and including a lot of new information, presumably, that will be introduced on the March 5th date.
If I may, her testimony had started a number of hearings ago, and so there's been plenty of time, including many weeks now, between these hearings and the March hearings, that the city has the documents. We've been providing the exhibits that we're introducing, so they can be prepped to at least start the cross-examination by that point.
I understand. My point is just trying to figure out how long each of you plan to take so that we can start focusing on when we might accept have public input. Or public testimony, I mean, not input, but public testimony. So if you're thinking you will be done with your examination on the 5th at some point, more than likely, you'll take the whole time. Do you have other witnesses as well?
We do. So we will have one additional witness at this time. Gary Young will be testifying. And then the city would have their opportunity to cross if they want to pursue that. And then we would be into rebuttal witnesses at that point.
Okay, so would it be fair to think that you would require the 6th to do the cross-examination, or is that not enough time, not sufficient time?
I believe that we should be able to proceed through our cross-examination of Ms. Heim on the 6th. That's correct.
Okay. So are commissioners available on the 5th and 6th of March?
Yes.
You all look so excited. Okay, so the commissioners are available, you all are available, so it looks like we will continue our public hearing meeting tonight. That is a special meeting for the commission on March 5th in the council chamber starting at 6:30. And the plan would be to go to 10 o'clock again, and that seems to be a reasonable period of time. And so with that, I think we are adjourned.
Thank you.